Blessings in Jesus' name. So just about to tell you about, I was just approached about a district court appeal on a civil order ban that was put in place by the district civil court, which of course it's out of their jurisdiction to deal with matters of a criminal nature. So the District Court of Appeal initially had members of An Garda Síochána involved in some form of prosecution, which of course is against the laws of this land, because the High Court has ruled recently that members of An Garda Síochána are not entitled to prosecute in court. Not only are they not allowed to prosecute in court, they're not actually allowed in a civil court, period. So they're not allowed to summons you to civil court to deal with a matter of a criminal nature, because the civil court doesn't deal with matters of a criminal nature. Therefore, anything that arrives in the civil court cannot lead to criminalisation of an individual, especially when it was on foot of a member of An Garda Síochána prosecuting, or a member of An Garda Síochána representing the evidence of another member of An Garda Síochána. So this has been ruled in the High Court. They're not allowed to do that. So obviously anything that would arrive or culminate as a result of that initial breach of the law, which is a guard prosecuting in the court, especially a civil court where he has no jurisdiction, cannot obviously lead to the criminalisation of an individual. It cannot stand because they haven't established jurisdiction. So I was just approached by Wexford Guard, who said there's something going on in the district court, an appeal that you put in to the circuit court. Now, of course, anything in the district court will be appealed to the circuit court. But the thing is this, that the circuit court appeal went in, and I was told that the adjournment was granted on the appeal on the basis that the constitutionality of section 115 and 117 was being tested and scheduled to be tested in the High Court. So the circuit court judge said, we'll give you an adjournment on the basis that the High Court are going to test the constitutionality of the sections under which you were first brought in to the court. So the thing is that they were telling me, you're not breaking the law, but we're going to take you before the district court. So there's a bit of a disconnect there. Why are guards summoning people to civil court? It's not their role, it's not their jurisdiction, it's not their place. And so if they're doing so, they're breaking the law. So very simply, they're breaking the law if and when they try to prosecute somebody in court, whether it's a civil court or a criminal court. They're breaking the law when they get involved in civil matters and choose sides and are partial towards one party involved over another, period, because they have to show impartiality. There has to be presumption of innocence. So all of these things were violated by section 115 and 117, 113 and 114 of the Criminal Justice Act 2006. So now I have guards approaching me, telling me that there's an appeal up in the courts, when actually the appeal was adjourned on the basis that the High Court were going to test the constitutionality of section 115 and 117. The High Court failed to test them, and the High Court quashed my convictions. So they failed to test the constitutionality of those sections while they quashed my convictions. Then an appeal was entered in by the state in the Court of Appeal a month and 4 days late, which means that they were out of time to appeal. They didn't apply for any extension to appeal, yet the Court of Appeal entertained their appeal. This is corruption. So now you have all these different layers of corruption. Guards operating in civil court where they shouldn't be, guards prosecuting in court when they shouldn't be, guards actually representing the evidence of other guards when they shouldn't be. And this has all been ruled by the High Court. They're not entitled to do that. So the actual initial court case was outside of jurisdiction. It was an actually unlawful act. So anything that arises on foot of that is obviously only justified if it is actually testing the constitutionality of those sections and quashing the convictions. They're the only justifiable motions, and actually compensating the individual who has been ostracised and defamed by the prosecution, by the initial charges which have been since quashed. So obviously, when the Garda now approaches me and says there's an appeal entered into the district court, or an appeal entered in to the circuit court on the basis of a district court charge or ban, and that circuit court has said, well, we'll entertain an adjournment, we'll grant an adjournment on the basis that the High Court are going to test the constitutionality of those sections, then obviously the sections are being ignored, really. They're being willfully ignored by the High Court, even though they found that the charges should be quashed according to the law. So now we have a barrister at law accusing me that I agreed with the judge of the district court in the first place that I behaved in an antisocial manner. He actually said that in open court in the Court of Appeal before 3 Court of Appeal judges. This is the highest court in Ireland. This will show you how defiled, how corrupt the barristers at law have become, when they will, in the absence of any evidence, in the absence of having been present in the district court, accuse me that I actually agreed with them when they said I behaved in an antisocial manner. I ask you this: what reasonable man would enter in an appeal of the decision of the judge if he agreed with the decision of the judge? What reasonable man would disobey a civil, or not comply with, rather, a civil order when he agreed with the ruling of the judge? This is just inconsistent. It's basically inconsistent. The two don't actually occur. They're mutually exclusive. You can't appeal a decision and agree with it at the same time. So there are motions in place and in order that show that this barrister was lying to 3 judges of the Court of Appeal, outright lying to them, when I have evidence to the contrary in the form of the digital audio recording, the DAR of the initial court case, which is up on my Facebook page. The DAR of the initial court says that I didn't agree. And actually I asked the judge, I asked him, do I have reasonable excuse not to comply with this civil order? And of course I did, because the warning of the civil order says in print on the at the end of any civil order, it says, warning, you must comply with said civil order unless you have reasonable excuse not to. Why would I consider that I didn't have reasonable excuse not to when the judge was telling me you're free to go? If the judge is telling you you're free to go and you're a free citizen, then you must expect that you have the right to engage all of your freedoms. That would include speaking and recording in public, in anywhere in Ireland. So they can't prevent you from, utilising your freedoms and your full spectrum of rights, and in the same sentence say you're free to go, Mr. Talon. So if you're free to go, you're free to speak. So the two are contradictory. Obviously one statement contradicts the other. You're free to go, but you're not free to... So obviously it's reasonable that if a judge is telling me I'm free to go, that I would expect that I'm free to speak. What judge of any court can tell a man he's not allowed to speak? That it doesn't exist. That in no place is it in any law, in anywhere in the world, that a man is told he cannot speak. This is ridiculous. Obviously if a man is free to go, he's free to speak. So this is a corruption. This is obviously high treason. This is obviously corruption of state. It's obviously a breach of the law. And the fact that the High Court have ignored the testing of the constitutionality of the sections under which these rulings were said to have been made is clearly evidence that the High Court is also corrupt in its dealings. And what they're trying to do is avoid the inevitable, which is the testing of the constitutionality of those sections. But we have found in the High Court very recently that it has been ruled by a High Court judge of the Courts of Ireland that it is against the law for a member of An Garda Síochána to prosecute in court. Well, Section 113 and 114 incite a member of An Garda Síochána to prosecute in the court of law in Ireland. So here we have sections under which I was brought into the court telling guards to do something, inciting guards to do something which is against the laws of the land. And it has been recently ruled to the same effect, that it is against the law for a member of An Garda Síochána to prosecute in court. It is against the law for a member of An Garda Síochána to even represent anybody in civil court. It is against the law for members of An Garda Síochána to represent the evidence of other members of An Garda Síochána in their absence. So no superintendent can gather the evidence of members of An Garda Síochána and represent that evidence, because he wasn't there, he didn't accumulate the evidence himself, he cannot corroborate it, he cannot stand by it under oath that it's factual, that he gathered it himself, and therefore he's not entitled to represent the evidence of another member of An Garda Síochána in court. But these sections under the Criminal Justice Act 2006 incite guards to behave in this manner. So obviously these sections must be tested, and the fact that they were scheduled to be tested, the fact that there was a circuit court appeal based on a circuit court appeal adjournment based on the fact that the High Court were going to test the constitutionality of these sections is blatantly obvious corruption of the court. So clearly we have evidence, many layers of evidence at many different stages of the function of the court, that they're engaging in corruption and high treason to try and kick it down the line and, prolong the corruptions that are in place. The failure for them to compensate me for their interruptions and interferences in my life and my freedoms, when it is actually their role, their foremost and primary role, to ensure that a man's full spectrum of rights are reinstated as soon as possible. And here they are continuing to kick things down the road. They're scheduling things in the High Court for testing against the Constitution, and then they're actually failing to do that. I mean, this in and of itself, being that there was a Circuit Court appeal adjournment given and granted on the basis that they were undergoing the testing of those sections, is in and of itself evidence that the court is corrupt and that they're dealing corruptly. The fact that I'm now being approached on the street by members of An Garda Síochána is telling me that there's that my appeal is scheduled. What appeal? Sure, the appeal adjournment was granted on the basis that the High Court were testing the constitutionality of those sections. So until the High Court tests the constitutionality of those sections, the appeal cannot take place. But the appeal is still adjourned, because it was adjourned on the basis that the High Court were going to test the constitutionality of those sections. So until the High Court tests the constitutionality of those sections, the Circuit Court can't proceed. So there's an incumbency upon the High Court now, placed on them by the Circuit Court, that they must test the constitutionality of the sections under which I was first summoned into civil court. They are the adult behaviour warning sections 113, 114, 115 and 117. Because you can't test 115 and 117 without testing 113 and 114, because 115 and 117 take their meaning and definition from 113 and 114. It has been ruled in the High Court of Ireland, I'll repeat and end on this, it has been ruled in the High Court of Ireland that members of An Garda Síochána are not allowed to prosecute. It is against the law for them to prosecute in court. In other places it is known that members of An Garda Síochána don't have jurisdiction in civil matters. They simply don't. It's against the law. They don't have jurisdiction in civil matters. So members of An Garda Síochána, not having jurisdiction in civil matters, cannot summon somebody into civil court to prosecute them. They cannot prosecute them in criminal court. Therefore, least of all can they prosecute them in a court where they've no jurisdiction. So clearly here we see that there's criminality and corruption in the High Court, in failing to test the constitutionality of the sections where an adjournment of the Circuit Court was granted. We're seeing corruption that the Court of Appeal are accepting appeals on the quashing of my convictions from the state a month and 4 days late, after the final date where an appeal could be entered in. A month and 4 days after that final date, that closing date, they entered in an appeal and the Court of Appeal accepted it. They accepted an appeal a month and 4 days late, without any application for an extension to appeal. They're not following the rules of the court. They're operating outside of jurisdiction, they're operating outside of the rules of the administration and procedures of the court, the administrative protocols of the court, and they're failing to implement them correctly. And here now I have members of Garda Síochána telling me there's a Circuit Court of Appeal up on the 15th. No, there's not, because it's pending the testing of the constitutionality of 115 and 117. So there's an incumbency placed upon the High Court to ensure that that's carried out. And we even have a ruling of the High Court stating that guards can't prosecute in court. They're just not lawyers. They're not educated. It's not within their remit. It's not within their station. It's not within their office to prosecute in court. They're not qualified to do so, and they have to remain impartial, which would certainly see them not being allowed to favour one party and prosecute on their behalf. You cannot have both. You cannot have impartiality. You cannot have presumption of innocence. You cannot have due process of court and tell guards they can prosecute and pick and choose who they're going to. This is obviously corruption of court on many different levels. Jurisdiction, presumption of innocence, impartiality, due process of court, everybody being held equal. How can everybody be held equal if the state are representing one party and not the other? Now we have the state and its barristers representing a conspiratorial group of shopkeepers. The state are representing a conspiratorial group of shopkeepers. Sure, we can't have this. The state are representing a conspiratorial group of shopkeepers against the High Court ruling, which says that my convictions ought to be quashed and were quashed. How do the state and the conspiratorial group of shopkeepers think that they know better than the High Court of Ireland? How can the High Court of Ireland and the courts of Ireland entertain such an appeal? They can't, not lawfully. So we must then expose this corruption to the nth degree, and we must do it before the God of heaven. Because at this point in time, the High Court have ruled that guards can prosecute, yet there are sections of legislature still in place, haven't been removed yet, that say guards can prosecute in court. So that's a big disconnect. There is a failing, therefore, and a failure, therefore, on the High Court that saw that guards were prosecuting in court and shouldn't be, to fail to actually remove those sections, or to go about removing those sections, is a failing on the part of the High Court that ruled guards can't prosecute. Because if there's any extant legislature that says guards can prosecute in court, it must be removed on the basis that the High Court ruled that they can't. And it didn't even require the High Court to rule that they can't prosecute in court, because everybody knows that. Guards aren't lawyers. This is very simple. I mean, this is rudimentary. If you didn't know that, and you were in first year of law school, and you didn't know that, you wouldn't pass your tests. And here we have the highest paid barristers and court judges failing to implement the basics that you'd fail your exams for, not knowing, in first year of law school. And this is very fundamental to law. It's very basic to law. And here we have them sitting on their thrones in the courts, complimenting each other as they lie about the people in the court. Barrister at law said that I agreed with the judge that I'd behaved in an antisocial manner, and I might say differently now. What kind of childish nonsense is that? This is absolutely corrupt. I mean, it doesn't get any more corrupt than that. A barrister at law, basically, the last thing he says before the judge says, right, that's all we're going to hear today, is a barrister at law stating Stephen agreed that he had behaved in an antisocial manner. Who agrees with the judge and then appeals his decision? Who agrees with the judge and then doesn't comply with his order? This is nonsense. But a barrister at law in the Court of Appeal of Ireland before three highly paid court judges is uttering this nonsense in the court, basically defaming my name, libelling me and lying about me in the court. Sure, I have a right to a good name. If he's going to say that I did something that goes completely contrary to every motion of the court that has ensued thereafter, he has to back that up, and the judge didn't even ask him to. He didn't even ask him to show that that his claim was true. But sure he can't, that's why he didn't ask him. They're trying to do a stitch-up job. Imagine a barrister at law standing in the court lying about the basic position of the person they're there to against. Listen, if I agreed with the judge, I wouldn't be standing in the Court of Appeal. I mean, the very fact that I was standing there means that the barrister was lying. But the judge didn't reprimand him. If I'm standing in a Court of Appeal defending my position for not complying with the civil order, how can he say that I agreed with the civil order? The very fact that I'm standing there makes him a liar. But the barrister at law is uttering this complete childish nonsense. Like a child saying, I didn't take the cookies out of the cookie jar when the cookie's in his hand. I mean, that's what we're down to now. It's absolutely fraudulent, unlawful nonsense. I mean, look at the state of the country. The absolute state of it. A barrister at law saying, I didn't take the cookies out of the cookie jar when the cookie's in his hand. He's basically telling the three high-paid judges, this man agrees with me. That's why he's standing here against me. That's why we're appealing the decision that was in his favour, because he agreed with the judge in the first place. What? Who appeals a decision they agree with? I mean, I will be seeking the digital audio recording of the Court of Appeal on that day, and it will be seen that that barrister at law lied. They're lying. Absolutely blatantly lying now. Even barristers at law representing the state of our land. They're representing the corrupt state of it. State of corruption that's in it. That's what they're representing. They're not representing the laws of the land. They're representing the corruptions, the satanic narratives and agendas of the, extremist liberalist groups. They're not representing the rights and freedoms of an Irish person. They're not representing the laws of the land. They're not interested in upholding the rights and freedoms of the individual Irish person. They're interested in the extremist liberalist agenda and implementing it. So, any barrister at law that blatantly and outright states before the Court of Appeal, before three court judges of the Court of Appeal, that the person he's trying to prosecute and appeal the quashing of his convictions has agreed with him is absolutely and blatantly lying. The very fact that he's standing there exclaims his lie. How can you say, I agree with you, but I disagree with you at the same time? Why would I be standing there disagreeing with the barrister at law, but he claims I agree with him all along? Well, he agreed with the judge that he behaved antisocial. Imagine that. While I'm standing there in opposition to him, he's telling me I agree with the ruling he's trying to have enforced. This is preposterous. If I believed that I'd behaved in an antisocial manner and agreed with the judge, why would I appeal his decision? Why would I ask him at the end of the day in court, do I have a reasonable excuse not to comply with your order if I agreed with his order? This is ridiculous. It's absolutely preposterous. So they're outright, blatantly, like a child being caught with their hand in the cookie jar, saying, I didn't do it. He did. That's what we're down to now in the Court of Appeal. I mean, the highest court of our land, three highly paid judges, the highest court of appeal of our land, not reprimanding a barrister at law who outright states Stephen agreed with the judge in the first place that he'd behaved in an antisocial manner. I mean, this is preposterous corruption. I mean, you wouldn't allow a 7-year-old behave like that, least of all a barrister at law who's a highly paid individual behaving like a bold child with their hand in the cookie jar. I didn't steal the cookie. That's basically what it is. He's there lying, trying to steal my rights from me, saying I agree with him in the first place, that I said he could take the cookie. I mean, this is preposterous. I don't agree with any court judge that says that I've behaved in an antisocial manner. I haven't behaved in an antisocial manner. I've never behaved in an antisocial manner, because antisocial behaviour is criminal behaviour, and all the way along the guards have been telling me, you're not breaking the law. Every interaction I had with the guards, they told me, you're not breaking the law. But while they were telling me I wasn't breaking the law, they were giving me adult behaviour warnings. There's a real disconnect. If you're not breaking the law, the guard shouldn't be handing you anything to tell you to cease and desist. So either they can arrest you or not. It's really simple. So antisocial behaviour is criminal behaviour, but it has to be a crime before it can be antisocial. Do you understand what I'm saying? For example, there were guards on the Luas, and they increased the amount of them on the Luas because there were violent attacks. People were actually attacking each other and beating each other up. Of course that's antisocial behaviour, because it's criminal behaviour. It's criminal to assault somebody. It's also criminal to intimidate and endanger others. So, I mean, there they are on the Luas, beating each other up, maybe falling on some old person or potentially endangering another person. And of course the guards are going to be there calling it antisocial because it's criminal. But if something isn't criminal, it can't be concluded that it's antisocial. I mean, this is really basic stuff, guys. I mean, this doesn't take a lot of intellect. And there they are, full of demons, incapable of doing anything reasonable or straightforward. And that's what it is. A barrister at law standing in the Court of Appeal saying Stephen agreed that he'd behaved in an antisocial manner. He agreed with the judge. He might say something different now. What do you mean he might say something different now? Why would you even think that I would say something different now if I agreed with the judge? Why would I appeal the judge's decision if I agreed with him? Why would I ask him? Why would I ask him? Why would I say that to him? Why would I ask him, Judge, do I have a reasonable excuse not to comply with this civil order? Why would I ask him that if I agreed with him? If somebody agrees that they behaved in an antisocial manner, they're submitting that they're guilty. At no stage did I agree with any court of this land that I'm in any way guilty. No stage. So what's the barrister at law saying I agreed with the judge for? That doesn't make sense. Do you see the point? Doesn't make sense at all. So in their corruptions, they continue forth, lying about the basic position that I stand in, the basic position that I take. The position that I take is I'm innocent of any antisocial behaviour. Why? Because I haven't broken any laws. What law have I broken, actually? None. Well, then how can you conclude that I behaved in an antisocial manner? And that's where it is. I mean, all of the behaviours that they've gone through in order to try and claim that, you know, lawful behaviour and rightful behaviour is criminal behaviour or antisocial behaviour in and of itself. The conduct that they have had to engage to try to, you know, claim that I'd behaved in an antisocial manner is all criminal, which exposes the criminal nature of their initial claim, because they've had to engage in criminal conduct in order to claim that I've behaved in criminal conduct. You see the point? When a judge of the High Court says, when I asked him, when he said, this court finds that you behaved in an antisocial manner, they didn't give any reason why they came to that conclusion. None whatsoever. Not even in the final ruling of the court, not in the written ruling or conclusion, nothing. Nowhere did the judge say, we find that Stephen has behaved in an antisocial manner because. That hasn't occurred. They haven't given any reason for concluding that I behaved in an antisocial manner. And so they can't, because antisocial behaviour is criminal behaviour. So because they can't say Stephen committed a crime when he did, they can't claim that I behaved in an antisocial manner. They still can't do that. They still can't say Stephen behaved in a criminal manner when he did, because I didn't. I didn't break any law. Do you see the point? So the criminal conduct is on the part of the courts, on the part of the guards, and that has been exposed for all of the aforementioned reasons. So I encourage you to look back at this video and you'll see why what the courts are doing is criminal. There's still an adjournment of a circuit court appeal pending on the basis that the High Court will carry out what they have scheduled. And what the High Court have scheduled is the testing of the constitutionality of Section 115 and 117 of the Criminal Justice Act 2006, which would also call into question Section 113 and 114 of the same Act, because Section 115 and 117 take their definition from Section 113 and 114. What I mean by that is when the terms adult behaviour warnings are used, well, they're defined in early sections. So Section 115 and 117 are based upon Section 113 and 114 and the definitions and meanings and mechanisms that come thereafter. Well, we've found that the High Court of Ireland have ruled that the judges cannot accept guards prosecuting in their courts. And so because judges allowed that to happen, the jurisdiction wasn't established. So anything that was ruled upon as a result of a member of An Garda Síochána prosecuting or representing the evidence of another guard, evidence that they themselves didn't gather, like for example when the superintendent under the adult behaviour warning sections comes in and represents guards of a lower rank who've compiled and conspired together to bring somebody into a civil court where they have no jurisdiction, and the superintendent tries to represent their evidence, then obviously he's out of jurisdiction and he's operating outside of his office because he's not a lawyer, he's not a solicitor, he's not entitled to prosecute, period, because he's not a lawyer. So he's not. The High Court have ruled that the High Court cannot permit the guards prosecuting, that the civil court cannot permit it, that the district court cannot permit it, that the circuit court cannot permit it, that any and every court of this land cannot permit members of An Garda Síochána prosecuting, because it would see that they're favouring one side over another in a court of law. They're not allowed to do this. They're only allowed to give their own evidence and the evidence that they've accumulated, and that's all they're allowed to do. They're not allowed to favour one side over another. They're not allowed to certainly not allowed to prosecute on behalf of one side over another. I mean, they're not lawyers, and even lawyers have to remain impartial. They're only allowed to basically represent the position of their client. Do you see the point? And pick apart the prosecution if they're, on the side of a defendant. So, I mean, why the state would ever be trying to overrule a decision of the High Court is beyond me. I mean, the High Court is where we look to get that, confirmation as to whether a section is, correct or incorrect, whether it's constitutional or not. So this is why we appealed for judicial review to the High Court, which the judicial review was carried out, and they found that the judge didn't behave according to the law, and that's why they quashed all the convictions. All of them were quashed. And I was told, you're free to go. That's it, you're quashed, you've won your case. Then a month and 4 days late, the state entered in an appeal which shouldn't have been permitted. So why are the state in opposition to the High Court? That's what I would ask. Why are the state opposing the barristers at law in the High Court? Surely the state look to the barristers at law to discover whether something is correct or not. And the High Court have said that it's against the law for a guard to prosecute in court. But still, why aren't they addressing the sections that say he can? These are 113, 114, 115, 117 of the Criminal Justice Act 2006. Still they're leaving that unfinished. And then they're coming to me trying to pressurise me saying, oh, there's an appeal in the circuit court. Why? Because they want to get access again to say that They want me to re-engage them so that they can say, no, your appeal wasn't successful. What do you mean my appeal wasn't successful? The convictions were quashed. The judicial review was carried out and the convictions were quashed. Any circuit court appeal that may be still in existence has been adjourned pending the testing of the constitutionality of Section 115 and 117. So it's incumbent upon the High Court to carry out what they scheduled. And all they said was, it remains an open question as to whether 115 and 117 are constitutional or not. Why would you leave that an open question and then accept an appeal on the quashing of the convictions, when the testing of the constitutionality of those sections would totally quash the convictions without any opportunity to appeal them, because it would find that the legislations and the sections that first saw me brought into court were unconstitutional, and so it would fall like a house of cards. If the sections under which somebody's first brought into court are unconstitutional, anything that happens thereafter has to be thrown out, except of course the testing of the constitutionality of those sections. But they're dancing around that. Why? Because they don't want it to be seen with finality that those sections ought to be removed with immediate effect. But we already have that position. And what I mean by that is, because those sections say that a guard can prosecute in court, they must be removed, because the High Court have said they can't. So guards are no longer allowed to prosecute in court. Did you know that? They were never allowed to. It's just that nobody had pointed it out, that they were breaking the law. So they have to submit and concede that the sections 115 and 117, 113 and 114 should be immediately removed. Adult behaviour warnings are against the laws of Ireland. You cannot persecute the life of a person by telling them you're engaging in your rights and freedoms, you're not breaking the law, but you must cease and desist or I'll bring an ASBO down. Guards using terms like ASBO. We don't even have ASBOs in Ireland. They don't exist. That's an English thing. In Ireland, there's a adult behaviour warning, and it's unlawful because it attempts to see a guard prosecute you in court. That's not allowed. If the guard can't arrest you for breaking the law, how can he summons you and prosecute you? He's not allowed to do those things. So let it be seen by the highest courts of this land. Let the High Court carry out the removal of those sections, the testing of the constitutionality of those sections, which should be cut and dry. It should be very quick. The High Court have ruled guards can't prosecute, remove those sections. I mean, this is very straightforward and simple. Yet we still have a Court of Appeal with 3 judges accepting a barrister at law saying, I agreed that I behaved in an antisocial manner. This is preposterous. It's an absolute corruption. It's an absolute childish deviation from anything that can be considered reasonable or proper. Blessings in Jesus' name.